Welcome back, everyone, to Bullhorns and Bullseyes. Curtis, today's episode is brought to you by the letter C. Do you know why?
Letter C. C's in my name. Is it brought to you by me?
Nope. C is for cookie.
Cookie.
Ever watch
Cookie Monster?
Yes. Yes. We are going to talk about the evil big bad cookie monster today. It's also C stands for California. It stands for CCPA. It stands for all sorts of things. It does stand for Certified Yacht Rock. Got that out of the way. But what are we really here to talk about, Curtis? This is something I've seen you talking about with clients more and more frequently these days.
Yes. We're going to talk about cookies and privacy. It's been a concern with a number of clients recently. I think the clients that fall under GDPR and CCPA, about 2 years ago, jumped on the bandwagon, but now we have some of our small business clients who are starting to see that this is becoming more and more of a concern, and want to make sure that we have some of their questions addressed and maybe some resources that they could reach out to and get some more information. So we're going to bring on Amy Baddley onto the show from Varnum Law. Varnum's one of the larger law firms here in Michigan, about 200 attorneys, I think, on staff. And Amy came recommended to us as somebody who really knows this area well, specializing in data privacy and cybersecurity and all of those types of matters. And so really excited to have you on the show, Amy.
Great to be here. Thank you for having me.
Yeah. So we had an incident with a client earlier this year, if I could start with this, that we put, so they came to us, let's see, about a year and a half ago with some website needs, and we saw they had a cookie banner on the website already. It was just a pop-up. When I audited what it was doing, it was just a pop-up. Whether you clicked accept or reject, what actually happened with cookies behind the scenes wasn't configured, and they thought they were protected just simply by having the notice. So we have a process now where we audit the cookies that are firing. We get that all set up in Tag Manager, and then we use there's a few different third-party technology providers out there that can handle the cookie authorization process and handle the banner, as well as what's really important is the sort of audit log that happens on the back end of if somebody actually hit accept or reject. But we implemented a policy. We had their legal team review that policy. It was implemented. And then about a year later, they got faced with a suit from somebody in California, not thinking they fell under CCPA. But in sort of a indirect way, seasonal employees, they hit that threshold, whatever that threshold for CCPA is, and now they were faced with this lawsuit. They ended up not having to litigate, and I think they were all fine and good. It was somebody who was out trying to fish and find companies that they could target. And I think this is sort of happening. These, like, I call them ambulance chasers in the PI world, but there's these privacy chasers now who are trying to sue companies who aren't compliant to make a little buck. And so I think that was kind of scary for the client. Thankfully, we were protected, but now here I probably only have 20% of my clients with websites who I would say are fully implemented the way that they should be, and the rest are just sort of punting the ball down the road and saying, nah, there's not a Michigan law yet, and there's no federal law yet. So do I really need to do this? Because I'm going to lose analytics data. It's just cumbersome for people to do. Do I really, and there's going to be costs associated with it. So do I really need to do this? Do they, Amy?
Yes, they do. Yeah, for several reasons. And so the scope of what I would like to discuss today is kind of, we have a few different buckets at play here. The first bucket is kind of this overarching privacy bucket. And that encompasses things like cookies and privacy policies and having the right links on your website footer, having the right kind of internal processes too, not just what's outward facing, but internal to your company. So one element of that is kind of the cookie side. So the cookie thing fits under the privacy thing, if that makes sense. So both are important. We always start our clients with that high level assessment of what even applies to you. So that's where we always start with our clients, is talking about what applies, because we want to be tailoring things really specifically. And to your point, it's not as clear as it may seem. If you're a Michigan company, you think, well, no, Michigan law, I've checked the box, I'm done. It doesn't quite work that way. So I'm going to give you 3 reasons why it's a good idea to kind of do that assessment, and then we'll talk about what those thresholds even are. So the 3 reasons that I think are really important to consider, back in the day in 2018, when this stuff was brand new, regulators said, we get it. It's new. You're figuring it out. You're reading the rules. You're trying to figure out how it all applies. We're going to give you a cure period. We're going to give you even kind of an informal. Regulators didn't really enforce these things right out of the gate, out of respect for the fact that this all was all new and we were all catching up. Those days are in the rearview mirror. Unfortunately, for a lot of our clients, they're caught a little off guard because they've gotten used to that more passive regulatory dynamic. And we're seeing a lot more enforcement from privacy regulators, especially if your company is in a more highly regulated area already, things like healthcare, financial services. But I would even include advertising in that too, because privacy does get really specific around how you're disclosing data for the purposes of advertising and marketing in some situations. So, I think that is an area where gone are the days where you can kind of sit back and think, well, nobody's going to come after me, because if you are subject to these laws, someone may come knocking now. A second reason is increasingly it's becoming this is what's expected of you as a company to contract with other companies. If you want to be a vendor to, another company, I'm seeing more and more where maybe a small startup is coming to me saying, well, I'm not subject to the CCPA, but this is a great opportunity for me to partner with this much larger entity, but they won't even come to the table unless I'm CCPA compliant. And so that's another example of how it may kind of surprise you that you're kind of in the ambit here of when you need to comply with these if you just want to be in the marketplace.
Mm-hmm.
And then third, this is just becoming the state of play and what consumers expect. So I think all 3 of those reasons are becoming more and more true, day by day, month by month. So I think it's important to keep a pulse on all 3 of those dynamics, because they are all 3 shifting, and they're all 3 shifting in the same direction. As a 4th reason, and really to your point, we are seeing outside of kind of the regulatory environment where a regulator says, hey, you have violated this law, we're seeing a lot of litigation on the cookie side. And that's where things get expensive. So the cookie framework is a little bit different in that there are some elements to privacy laws that speak to cookie collection and use and the cookie banner say, but really that can fall under a federal privacy law, or really a federal law that's being kind of retrofitted into a privacy world. So we have things like it's called VPPA is one example of this. It's a federal law that was enacted in the, I believe, 80s to regulate how someone's video records, you go to Blockbuster and what I rent is no one else's business, and it's illegal to produce that. It's hard to believe, but this law has been retrofitted in a way that is implicated by a company's use of cookies on their website. It's a federal law, so not California specific, and it has a private right of action. So that's when you say these ambulance chasers in the privacy world are coming. It's through laws like this, where it has a private right of action, meaning a private person can sue, and every single person who says, my information was collected, even though I said deny on the cookie banner, my
Right.
information was still collected. Every single person could come to you with a separate lawsuit with big money attached. We're seeing an average settlement of around $20,000 each settlement. That's per user. So to your point of why should someone invest? There really is, you have the regulatory threat, you have the business risk, but you also have this litigation risk that's really special right now in that it could be big dollars if enough people come to you. 20,000 each settlement, that's going to add up quick. So that's why you invest on the front end, because you can do it for less than $20,000 and knock them all out.
Right.
So I think it's important to kind of call out these thresholds of how do we know what privacy laws apply? Obviously, that federal cookie related law, that's going to apply to everybody. When we're looking at California, how do you know if you have to comply with the California privacy law? There are 3 triggers. One is a minimum annual revenue of $25 million. The second one is you have to be generating at least half of your income through selling personal data or sharing it for targeted advertising. And then the third one is collecting the personal data of 100,000 people from California. So those are the 3 triggers we look for.
They only have to meet one of those 3? They only have to meet one of those 3.
Only one.
Right.
So even if you're a small business, say your annual revenue is $3 million, but you're getting half of your revenue by targeted advertising, you got to comply. So that's California, but user beware, because it is not just California anymore. We have 19 different state privacy laws at play now. And if you think legislatures were going to make it easy on you, you'd be wrong. They said, every single state sets a different threshold for when you have to comply with it. Now, it's pretty standard that a lot of these laws have a lot of significant overlap. And one of them is generally you do need to collect the personal data of 100,000 people from that particular state. But it's not always that way. Texas and Nebraska, for example, unless you're a small business, if you collect the personal data of even one person from either of those states, you have to comply with that state's law. So these things are shifting. They're a little bit less consistent than you might hope. And so it's really important to kind of find a good partner who can walk you through this, especially if you're a company that doesn't need to comply today, but keeping your pulse on the industry. And as you scale, you may be tripping these compliance wires without realizing it.
If you would both, just for a moment, because I imagine most people are still in the either the wait and see or it doesn't apply to me type of mindset, right? And as you suggested and demonstrated, we're not in that environment anymore. But I think for most of the layperson, right, who doesn't do what either of you do, a cookie notice is something that pops up for half a second before I get on with my business of my website. It doesn't pertain to me. As a business owner, I asked somebody, we have a cookie notice, so I think we're good there, right? Most people do not understand what is happening on a website. When you say collect data, most people would say their website collects no data. We don't have anyone where you could sign up for anything. We're good. Explain why this is so pervasive. We're talking about every website collects data of some sort. So just explain the basics for the lay person out there who's like, I've already tuned this out, or I'm about to tune this out. Fits me to stay because I don't think people fully get the gravity of the situation.
Before you say anything, Amy, I'll add to that the one customer story I was sharing, their marketing team, because it was a suggestion from LinkedIn to add the LinkedIn pixel on the website, that's what the person came after them to try to get, right? So they weren't really doing advertising even with it. It was really like a LinkedIn rep who was like, oh, you should get the pixel on the website so that we can do remarketing if you want to do advertising in the future. But they weren't really even using it. So, again, they ended up still being protected and everything was configured properly. But, this is where understanding each individual cookie that's on your website and its purpose, and then even declaring those cookies so you have transparency to the users that if they want to go and see what it is that's on the website or what it is they're agreeing to, you need to be transparent about that as well. And, thankfully there's these tools out here that can make it easy and it doesn't have to cost a lot. I think that's the difference in $20,000 per user fine versus maybe, $25 a month for a tool. Some of the cheaper ones are that, plus maybe an implementation fee. That's pretty low compared. And I do advise because we're not going to tell you how your business should comply. Say, talk to your general counsel or find an attorney that will do this for you, because the documentation, the privacy policy, the terms of use, cookie declaration, like all of this needs to match the way that it's all configured.
Yeah, that's right. Yeah. So to Tom's point, at a high level, well, and I should say, I always hope that if I just say cookie often enough, people will keep tuning in, because like, what a great word. I think that is like, that draws me in. Let's
Yeah.
just keep talking cookies.
Well, yeah,
That's
why
when we're
we're
kind of
calling,
legal compliance.
we call Curtis the Cookie Monster for this very reason.
Oh, I love that. The legal name change.
You could
There you go.
the Cookie Monster Blue.
That's right.
His eyes
I
aren't as
didn't get the
googly
memo.
as they normally are. But continue, Amy. Why is this more pervasive than people give it credit for?
Yeah. So almost everyone who has a website is collecting personal information. That's like where we start. So personal information is a really broad term legally, and it means really any information that, reasonably is associated with a specific individual or household. So we're talking about really anything that can be like linked to a person. So broad. And that includes, privacy laws are pretty consistent on this. That includes things like your IP address, or I should say a consumer's IP address, device information, website usage, all of that good stuff, all that information that's collected by cookies, to help all of those analytics details, conversion rates, what's working, how are people using your website, all that really rich information is flowing from personal data. And it's even tricky if you think it's kind of de-identified, or, I really don't know who it's associated with. De-identification under privacy laws is a legal term, and you may not actually be satisfying the legal term of de-identification. And so you may think, well, this is anonymous, but it's not actually satisfying that carve out. So it may still be considered personal data for the sake of complying with these laws. So again, another great reason to talk to your attorneys so that you're getting that really technical legal information, and you're not just going, I don't know, feels like I don't really know who this is about, so I'm sure it's fine. That's not the right approach here.
Right.
So when we talk, so now we've got the framework of, what personal data is. Most websites, almost every website is collecting it. Even if you're doing just, Google Analytics, unless you've got certain controls activated, that could still be personal data. Cookie banners are really important to get right, because there is that high litigation risk and settlement risk. So a couple notes on cookie banners. To Curtis's point, having the banner is just the starting place. It needs to work. So if you say, if you give people the opportunity to accept all cookies or reject all cookies, that better make a difference which button I press. Second thought is, at least in California, and in other state laws, there is a specific restriction against what's called a dark pattern. And a dark pattern means you are making it easier to accept all cookies than to reject. So if on the cookie banner, it says, your options are accept all or click my privacy choices, that's a dark pattern. If you're making it harder to find, or you have to click more buttons to opt out, dark pattern. So that's something that I think I see that all the time when I'm online, that technically that is not compliant with these laws, and people should kind of revisit exactly what a dark pattern is, because it is pervasive. Just because you see another website do it doesn't mean it's lawful. I get that all the time from clients. So a third thing I'd like to bring up is, we're seeing regulators more and more say, great, you recognize that you needed a cookie banner. You have one. There may be no dark patterns. Great. Even if you're using a third-party vendor to operationalize that, to give you that cookie banner and to run it on the back end, sometimes it's still not working the way that businesses think it is. And regulators have been really clear, you business are still responsible for legal compliance, and you're going to get dinged if your third-party vendor is doing it wrong. So you still need to know what is going on the back end, even if you are trusting that third party vendor, and hopefully they are doing everything correctly. But in those small circumstances where things are not, that vendor missed something, business, you are still responsible for that legally. So you need to make sure you're understanding what the law requires and making sure things are firing the way that you think they are. So cookie banners are really technical. It's important to do that auditing and to make sure you've got this isn't difficult work, but like many areas of the law, it's just a little nuanced. So having the right partner beside you can really matter. And again, when we're talking about $20,000, every single person who finds a plaintiff side attorney who comes after you, this can be very expensive for especially companies that don't have a lot of cash on hand for settlements like that.
That's in our statement of work there. It's you review our work, and at the end of the day, you are responsible for your own website. And we could have missed a setting or something like that. While we'll do our best to validate what it is that we're doing, and that's where I've strongly urged everybody, bring an attorney, a privacy attorney in on this, who not only can write your, because a lot of people are like, oh, will you also give us a template for the privacy policy? It's like, no.
Way.
Right. Well, yes, you can find templates online. You could go to legal tools and different things like that. There are websites who can create templates for you. That doesn't mean it's right for your business. It's right for your scenario. You need something that's right for your scenario. So have all of that match.
Yeah, that's right. In privacy, one of my favorite things is that almost nothing is prohibited. You just have to accurately and comprehensively tell people what you're doing. And so generally, I love this area because I always get to tell companies, yes, you can do that with data. Yes, you can monetize it. Yes, you can sell it. You can, gather analytics. You can do what you want with it. But the most important part of privacy, what these laws are really getting at, is to make sure that people have full information and that be both accurate and comprehensive. And so if you are telling people that you are, giving them the right to opt out of that cookie use, you better be doing it. And if that's why, to your point, it's really dangerous to use privacy policy templates, is because these things, your privacy policy, the whole point of its existence is that it be tailored to your data processing.
Right.
If that privacy policy is not accurate to what you're doing, now you've introduced new risk to yourself than had you not even had a privacy policy to begin with. So I'm not saying it's lesser risk, but it's new risk. And so that's something that I think a lot of people miss, is like you just open the door to like new problems.
Right.
So it's not a hard thing to get a privacy policy right, but it's not just, it's not a copy and paste from someone else online.
It sounds to me like there's so many stakeholders that should be at the table for this, because obviously we have legal, you might have IT. We've got now in Curtis's case, who's ever managing the website. We might have somebody in marketing who may want to collect data, right, for advertising purposes, and may just be off doing it without telling legal or IT. So like,
you have HR because you have these career pages and stuff like that. So you've got human resources that's involved in the conversation.
Yeah.
Yep.
I mean, who are we missing, Amy? And then my second question is to both of you. Where do you start? Everybody's going to want to do their own sort of audit, right? Because Curtis, you have an audit, and I'm sure Amy, you have an audit. Like, where do you guys suggest somebody starts?
Yeah. So who should be at the table? Generally when I'm kind of building a compliance program with a particular company, I am working a lot with IT and legal. But I expect that the legal department has a really good pulse on operationally what's happening, in its product development, in the services it offers. And, sometimes I'm partnering with smaller companies where there's a really good sense of that because you've got a limited number of players in the company. I've also done privacy work with a major OEM automaker. So now we're talking about, we have vehicle data that's all over the place. We have business data, HR data. You've got more data than a lot of people can conceive. And so that's where the level of privacy compliance really goes up exponentially when you're talking about a lot of data and sensitive categories of data. So I think it's flexible, right? Privacy doesn't need to be this huge legal spend, and it doesn't need to take up a ton of your time. For an average company that has moderate amounts of data and it's doing kind of the typical things with that data, that's something we do routinely. But if you're the more highly regulated space, you're really going to want to give it a lot of attention because a regulator will. But where to start? I think every company should start in the same spot, whether you're big or little. I love it when companies start with data mapping. So this is the process in a simplified form where a company tracks every element of data that it collects from consumers online, in person. Maybe you're gathering it from a third party, not directly from the user. You're tracking every single bit of personal information that comes in your door. You're tracking it within your company. Is it going to HR? Is it going to a third party vendor? Is it going to, any other product team? And then you're tracking it. When does it leave our company? Are we giving it to, are we selling it? Are we giving it to that third party vendor? Are we deleting it? Do we have, a retention policy that would govern this? So mapping the data from the time you get it to the time it leaves or is permanently deleted, I think is a really valuable exercise because that's when you can build an accurate and comprehensive privacy policy. You can satisfy, we've talked about these cookie banners, cookie notices, privacy policies, terms of use. All of that is external facing. These are the external obligations under these privacy laws. But I think it's a big fallacy to think that privacy laws really just require those things. Privacy laws also require that you have certain contracts in place, that you have data protection assessments that you're doing internally to weigh the pros and cons of certain sensitive data processing, that you have certain security in place. And so all those internal things are important too. And data mapping is going to help you comply with every single element. Another example, say a consumer says, you know what, I'd like my data to be deleted. They exercise their right to have their data deleted, which they get under every single privacy law in this country. If a consumer reaches out to you and says, I'd like my data deleted, you better know where that data is because you have 45 days to complete that request and have your vendors who get that information also delete that data. So my companies that start with data mapping, they know exactly where that data is and they can execute within that specified time frame. So I think for a lot of reasons, data mapping is really valuable, but it can be, it's not legally required. So a lot of companies would prefer to just say, okay, what are my obligations? And I'm going to check those boxes. And, I understand that too. And we can certainly go about it that way and just do it a little bit ad hoc and kind of looking backward. But anytime you can, we have this term in privacy called privacy by design. And that really just means embedding privacy principles into your products, your services, your internal workflows. That's just going to make it easier for you on the back end if you've already built everything to be really privacy friendly along the way. You're not retrofitting it into this privacy box. Things just operate a lot smoother on the back end. So anytime you have the opportunity to do a little bit of privacy by design, that's really beneficial. That's what data mapping gets you. Otherwise, if you'd say, I'm skipping data mapping, I would say your next step is any privacy obligation that is external facing, that a consumer or a regulator could look online and see, oh, do you have a privacy policy? Do you have terms of use? Do you have, is there somewhere that I can opt out if I have if I have a right to opt out of having my data sold or shared for targeted advertising? All of those external things, get those right, because that's the low-hanging fruit that gives people the tip off of, oh, look, I can do a little more digging and find
Right.
additional gaps. So start there and then get your internal house in order, and kind of get those internal processes right too.
You said something, Amy, that made me really think of a gap that we have, and that what we do in our audit is review all of the tags that are firing on the website, of course, because as the webmaster, at least with our clients, usually we're being asked to add these pixels, these cookies to the website. We use Tag Manager, which is easier to manage it than just throwing them all on the website. So thankfully, we already have Tag Manager. So kind of have this documentation in the Tag Manager, but then we can take it over, put it into a spreadsheet, sort through all of that with their general counsel or attorney, whoever, to determine, okay, what are all of these? How do we define them? How do we make sure they're in the privacy policy? Do we need them all? What behaviors are associated with them? But you said something that made me realize there's a gap in that. Tom, we have clients that use tools like Zoom Info, where on their sales team, they're collecting data, not necessarily through the website, but they're getting prospect data information from, trying to prospect essentially from a sales perspective, contacts and accounts. They might choose to email them or call them and reach out. But yet what you just said was this is still the collection of data, not necessarily through the website, and how you store and use that information. Or if you do call me and I say, hey, how did you get my information? I want you to delete it. You need to have a process for now taking that out of your Zoom Info or out of your CRM, right?
Yeah, that's right.
So it is
Yep.
more than just the cookies on your website. That privacy and the data collection side falls probably a lot further beyond just that sort of analytics collection.
Definitely. Yeah, yeah. And that's where kind of that broader privacy umbrella, where cookies are one element of it and a really important element. Privacy is bigger than even online privacy. We're talking about all kinds of personal data in any form, and however you're getting your hands on it. So you're right. I think a lot of times clients, it's always helpful. So I always start my compliance journey with clients on a phone call, or really Teams. But I don't like to operate over email, because I think there's so much that comes out in discussion just like this, where we start to brainstorm. Tell me about your business model. Tell me about the data you're getting. Where are you getting that? What are you using it for? Oh, you didn't realize that's also personal data? Let's talk about it. So I love starting with a really robust conversation, because all of my work gets easier and quicker when we can get all of it at the table, because, I don't expect anyone else to be a privacy expert. They don't know the scope of these laws. And so if I can get it all out on the table, that's hopefully, I'd like to think that's what I offer in the partnership is, I hold the technical knowledge, they hold the business knowledge, and together we're able to kind of frame it all out correctly.
It strikes me how quickly this is moving, because I think California adopted like the European model in many ways, right?
I'm
Yep.
sorry, did you say that?
I said that
California, the
adopted,
CCPA adopted the GDPR model.
which is the
And that goes back to before 2019, does it not, Amy? I'm trying to
That's
remember.
right.
Yeah.
That was
Yeah.
effective in 2018. Yeah.
and now
Yeah.
you said 19 states have some version of a law related.
Let's see how well I know this, Amy. I know like Colorado, Virginia. Well, you mentioned Texas, which I wasn't aware of Texas, but there are other states that are starting to follow suit. But even like companies here in Michigan have to realize you might be doing business with Canada.
Oh,
And
yeah.
so now you're falling, and they follow very closely to the GDPR rules, if I'm not mistaken. So,
Yeah. And they've had a total overhaul of Quebec's privacy law, which, lest you think it's easy in Canada either, that Canada has a broad national framework, and then they have 3 provinces that have enacted their own that don't track all the way. So in privacy, there's a lot of overlap, but it's never total overlap. So we have all of these, it's so patchwork. And so there's a lot of, and that's just privacy specific, right? So we have existing laws like the FTC's unfair and deceptive acts and practices law that also comes into play. The FTC says every business that makes any representation, it needs to be fair and not deceptive. So if you don't have a privacy policy, but you're collecting data, that could get dicey if you have a privacy policy that's not accurate. You could be violating FTC law, and that's not privacy specific. So there's I think people are often surprised to find that
Right.
regulators are lurking all kinds of places.
That's a scary place to end it. But the point being, though, I think, so I'll be the one to state either the obvious or the stupidly obvious, is that the internet really knows no geographical boundaries, really specific, right? It's like they're actually, oh, this person's in Michigan, even though they're on my California website. I'll collect that data a little differently than I collect this. So I think what we're talking about now is an environment where it all applies to everybody. Are we? Are we already
Yeah,
there, even if we don't have 50 state, specific legislation?
yeah, that's right. And it's I think uh, GDPR in the EU and Canada, those are both triggered if you collect the personal data of even a single resident. Now you technically need to comply with those. In the States, the state-based paradigm is that you kind of need to satisfy, a lot of states kind of carve out smaller businesses, and they want to give them room to grow before they become obligated under these laws, but not Canada and not the EU. So you're right. We're in a global world. If you're a mid-sized company or a larger company, there is every possibility, and in all likelihood, you need to comply with the 19 state privacy laws, which are different and in some ways actually conflict. You need to comply with Canada's privacy laws, all four, right? The national one in each of the three provinces. EU, I mean, that's just EU and Canada. We have China, Brazil, India. So in a global world, privacy is becoming increasingly, privacy laws are becoming increasingly prevalent, and it's an increasing risk that businesses are sorting through because, that's a lot of patchwork to be tracking. And every time you turn around, we have a new state law has popped up that isn't exactly like anything we've seen before.
I guess the
Would
moral of
you
the
care
story
to?
is,
Oh,
go ahead.
go
I'll
ahead,
let you
Tom.
finish. But the moral of the story to me is, if you are, as a business owner or a stakeholder in a business, if you're unclear, which I'm sure you are, on where you need to start asking somebody until you get the
Yeah.
answers that you need, both from legal, technical, advertising, etc. It's my final thought. Curtis, yours?
Yeah, and I'm not just passing the buck either with clients when I say, talk to the attorney. I'm being serious from that perspective, right? That it's I'm not going to put a template on your website. I'm not going to be responsible for that. I'm not just going to put up a banner. Let's do this the right way. And now's the time to do it. So I don't know if you care to opine on this, Amy, but I believe there was a bill that was introduced federally for a federal privacy law maybe a year and a half ago that I don't think went anywhere. Is that
No,
correct? And is there anything on the table that you foresee, coming? Anybody working on
no,
anything? No.
not anytime really soon. I haven't seen anything that I think is serious yet. Obviously there is an appetite to have a ceiling, right? Passed that would be, a federal law that would preempt all of these 19 plus state laws, so that businesses can reasonably comply, right? It makes sense. To Tom's point, we're in a global world. Let's get one U.S. law. But the backlash would come in the form of, California took a long time to hammer out its law. It was really specific and really protective of consumers. And so California and other states like it don't want federal preemption, because federal preemption would probably come in at a less protective level than CCPA. And so that would be the ceiling, so that, there isn't this patchwork. But it would be a trade-off, and that would be a little more business friendly to have this federally preempting law. You could, of course, have a federal law that set a floor where different states could come in above it. But, what's the point? Because now we're back to a patchwork approach, maybe just a little less patchworky. So I don't think, from a policy perspective, I don't think Congress has worked out whether there's the political capital to enact something with federal preemption yet. So we'll see. That conversation will definitely evolve. And we haven't touched on AI yet, but AI laws are that's also falling in my wheelhouse now. And AI laws are tracking how privacy laws came to be at the state level, and we have this patchwork approach. We're seeing that same model come in the AI space, where we have various states really with different legislative frameworks governing AI pop up. And I think we're going to start seeing more and more similarity, but not complete overlap, and still no federal preemption in AI either. So I think what's happening in privacy is really important to kind of keep a pulse on what can we expect in AI 5 years from now.
That could be a whole nother podcast.
I was just going to say, to be
Let's do it.
continued for sure.
Yeah.
Oh my gosh. Well, thank you, Amy Baddley, associate with Varnum. Let's make sure we get that right. Where could people go to have their data collect? I mean, to learn more about you and privacy and what they should be doing about it. VarnumLaw.com.
Yes, that's right. And if you're curious about the kinds of law that I work on, if these things are interesting to you, you can find my bio there and kind of get a scope of the things I work on every day. You can also find me on LinkedIn. I'd be happy to connect with you there.
Cool. And we will post links to all of that in the show notes. So as you're listening or watching, just look down below and click away. Thank you so much, Curtis. You ready for a cookie?
It is in the afternoon. An apple would probably be better. Don't you agree? Keep the sugar level in balance. I'll go for the apple instead of the cookie.
All right. You heard it, ladies and gentlemen. He is now known as the Apple Monster. Catch him next week on Bullhorns and Bullseyes.